Good morning, everyone. Welcome back to our course, The Law on Sales. This is third installment for this course, and I am your host, your professor, Attorney Lyndon A. Maceren. So again, the Law on Sales is part of the Civil Code, which was enacted in 1949 and took effect in 1950. So sales is part of the Civil Code. Now, in part 2, we departed with the note who bears the expenses of delivery. So in the provisions of the law, it is the seller. So that's the general rule. The seller should bear the expenses of delivery. Of course, also of the sale. No? The cost of sale or to the buyer. But if the seller and the buyer has agreed that the expenses should be passed on to the buyer, then the buyer agreed, so that would be an exception to the general rule. Okay. So now we discussed with another kind of sale is by description. Another mode of delivery is just by describing the goods. Like for example, you are going to show a sample. This is a sale by description or sample. So you're showing to the buyer a sample. So in the delivery, you must also deliver the same kind of goods. So it must correspond with the sample shown. Because if you will deliver, if the seller will deliver a low quality type of goods, then the buyer has the right to return the goods. Another kind of sale is by description. You just describe the goods that you are selling. So in your delivery, when the buyer already decides to buy, so you must deliver the goods that must correspond with your description or with your sample. So if there is no compliance to your description or to your sample, then the buyer may avail of the remedy of rescission. So rescission is cancellation of the contract, and then the result of the cancellation is restoration of the things. So the buyer will return the goods and the seller will return the payment to the buyer. Now let's discuss the obligations of the buyer. Of course, the obligations of the buyer is delivery of the price, so he must pay the price. The buyer is obligated to pay the price according to the terms agreed upon regarding the time, the place, and the amount. So where to deliver, the place, and when, and how much, the amount. So if the payment of interest is stipulated in the contract, buyer must also pay. If the amount of interest is not mentioned, then apply the legal rate. So the legal rate now is 12%. 12% per annum. But if the buyer will not pay and there is already interest, that interest will also bear another interest. So it will not be 12%, but only 6%, one half of the legal rate. Again, the legal rate is 12%, so if the buyer will not pay the amount, it will be slapped with a 12% interest. But when the interest already earns another interest because of the length of time, then that interest of the interest will now be 6%. Okay, when the buyer defaults in payment, it would constitute a breach. What kind of breach? Breach of contract or agreement. Now, it would be subject to the seller can demand for specific performance, which is delivery of the payment, or rescission, plus damages. And interest shall also be paid due to the default. Okay, that's as to price. Another obligation of the buyer is to accept delivery of the thing sold. Of course, the seller must deliver the thing, not partly, but as a whole thing. No. So when it is delivered as a whole, then the buyer is bound to accept delivery of the thing sold. So where should it be accepted, and what time and place? So it should be stipulated in the contract. No? If there is none specified, then it should be at the time and place of delivery of the goods by the seller. So there is acceptance if the buyer intimates to seller that he has accepted the goods, meaning he acknowledges the goods and then he accepts it. Also, there is acceptance when, upon delivery, the buyer does any act inconsistent with ownership of the seller. So, meaning he now utilizes the thing, the object, as an owner, or he accepts the thing and possesses the thing and uses it. So that is now be consistent as an owner. And on the part of the seller is now inconsistent as an owner. So this is written inversely. And third, when he retains the goods without intimating to the seller that he has rejected it. So this pertains to sale of goods on trial or return. No? There is a mode of sale which is a sales on trial or return. So if it is that kind of mode, then after an unreasonable period, the buyer keeps the goods without returning it to the seller, then he now uh, becomes his act would becomes now as an acceptance of the goods. So this would apply to the sale on trial or return. Then we have a sale of goods on installment. This is covered by the recto law. No? The recto law under Article 1483. Okay. So sales of goods on installment, these are goods must be delivered in full, as I have said. If the goods are partly delivered by the seller, then the buyer can reject the goods. So the goods must be delivered in full except when there is stipulation that delivery will be on installment. So when the goods are not examined by the buyer, then it is deemed as it is not accepted until it is examined, or at least had reasonable time to examine. No? So delivery of the goods by it is delivered in full. Payment is installment, but not examined by the buyer. According to the law, it is deemed as not accepted until the examination was made, or until such time, or until a reasonable time to examine has elapsed. No? What is reasonable time? Here in our jurisdiction or in the Philippines, uh, the buyer has the right to return within 7 days. Of course, it should not be based on a change of heart, but or a change of mind, but it should be on the product. No, the product must be out of order or not in good condition, which is not fitted for its purpose. It can be returned then exchanged with another good or exchanged with the same kind of goods if it meets the qualities that the buyer expected. So acceptance of goods in general, absent contrary express stipulation, if there is no stipulation, does not discharge seller from liability in case of breach of warranties, unless no notice or failure to give it within reasonable time. So the seller is still bound to make good of his warranties. No? If you remember, there are warranties in a sale. There are agreed warranties or implied warranties, no? Or warranties uh, which are governed by law. So another rule, when the buyer has a right to refuse goods, there's no need to return, meaning it is not the obligation of the buyer to return. And then he just communicates it to the seller. Mr. Seller, I am returning the goods. But he is not bound to deliver it to the seller. But he shall, in this case, the buyer becomes the depositary, meaning the contract of deposit will now play. Unless there's stipulation that he will not become a depositary. No? All right. So let's go to Article 1544. According to the law, if the same thing should have been sold to different vendees, meaning there are two different buyers, the ownership shall be transferred to the person who may have first taken possession thereof, in good faith, if it should be movable property. So this is the rule as to who will answer the question as to who is the owner of a movable property when it is sold to two different persons. So according to the law, the ownership shall be transferred to the person who may have first taken possession in good faith. So there must be good faith, because if there is bad faith or deceit, then the ownership will not pertain to this person. Okay. Now, if the property is immovable, meaning it's a real property, then the ownership shall belong to the person acquiring it in good faith, who first recorded it with the registry of property, which is now the registry of deeds. Registry of deeds. But if the property is without a title, this is what it means. No? There be no inscription, meaning that the property has no title. Then the ownership shall pertain to the person in good faith who was first in possession of the property. Whoever is in possession of the property, so he now erects a house in the property, he now cultivates the property, or he now fences the property, will now become the owner of the thing. And in the absence of possession, so if nobody is in possession, Then to the person who presents the oldest title, provided there is good faith. So if nobody is in possession, then this last paragraph will apply. The ownership will pertain to the person who presents the oldest title, provided there is good faith. So meaning it's not the title, but whoever presents a document which is the oldest, like a deed of sale which is dated the oldest, or a tax declaration which is dated the oldest. No? This type of documents, the deed of sale and the tax declaration, they're not uh, documents of title. Only a transfer certificate of title or original certificate of title is a document of title as to immovable property. So in those provisions, Article 1543 is pertains to double sale. You know? So double sale, so the general rule in double sale, so whoever is the first in time or the priority in right, so has the priority in right. So this is the general rule. First in time, priority in right. So meaning who is the first in time has the priority in right. Okay? So when does that apply? 1544, I'm sorry. When not all requisites embodied in 1544 concur. Okay? So it does not apply when not all the requisites. What are the requisites, by the way? So the requisites for double sales to exist, we have here an acronym, no? VOCS, VOX. So the first one is two or more sales transactions must constitute valid sales. So there must be two sales to two different persons. So that's the first. That's the first requisite. The V is here, valid sales, no? Okay. And the second, two or more sales transactions pertain to the same object or matter. So the O is here, same object or subject matter. Then two or more buyers at odds over the rightful ownership of the subject matter must each represent conflicting interest. So this is the C. Conflicting interests. So two or more buyers at odds over the rightful ownership of the subject matter must each represent conflicting interests. So not the same interest. No? And number 4, the last one, two or more buyers must each have bought from the very same seller. So only one seller. So in the case of Consolidated Rural Bank versus CA, Rural Bank CA, now it's Cagayan Valley Rural Bank. So according to the Supreme Court, if not all elements are present for Article 1544 to apply, I'm wrong spelling here, the principle of prior tempore or potion jury, or simply he who is first in time is preferred in right. So this one is the rule that will apply if 1544 cannot be applied, or if all the elements of 1544 is not present. So what are the elements of 1544? The one we just read, no? 1, 2, 3, 4, or VOX, valid sale, and then same object, and then two persons of this conflicting interest, and then one seller. No? So what is this rules? He who is first in time is preferred in right. So undisputedly, he is a purchaser in good faith because at the time. So he bought it first, no? So he bought the real property, and there was still no sale as to the second vendee. Okay. So there is no sale yet to a second vendee. So he's the first buyer. So he should be given the priority in right according to the rule. Okay. So if all the requisites of 1544 are not present, then we apply this rule. First in time is has priority in right. Okay. So again, we will these are the rules in 1544 as to movable. Whoever is the first to possess in good faith is the owner. No? Whoever is the first to possess in good faith is the owner. That's as far as movable properties are concerned. Now, as to immovable, the rule is that whoever first to register in good faith is the owner. That's the first rule. But if there is no inscription, not in written form or not registered, so the one who first possess in good faith is the owner. So first to possess is the owner in good faith. But if another rule, if there is no inscription and there is no possession in good faith, absent and possession, then person who presents the oldest title in good faith. So what is good faith? This is a person who buys property without notice that another person has a right or interest in such property. So he has no knowledge that anybody has a right on this property, and if he buys it, he's the only one who has interest in it. Or one who has paid the price before notice that another has claim or interest. So he already paid the price, but he has no knowledge. Then he got not noticed that another one has a claim or has an interest over the same property. So still he is in good faith. Okay. Lis pendens is a Latin term for uh, notice, no? You're giving notice that the subject matter is under litigation, meaning this property is the subject matter of a case. So if there is notice of lis pendens, which is written in the title, that is now a notice to the whoever is interested. No? So that's a bad notice. Oh, this property, you should know that this property is under litigation in a case which is still pending. No? So that's lis pendens. Another kind of notice is an adverse claim. So adverse is the another party. That's an adverse claim. So notice that somebody is claiming a better right over the same property. So you will file this in the registry of deeds, no? You will annotate this in the title of the subject property that you're claiming a better right, and the heading would be notice of adverse claim. These are definitions, no? Possession could be actual or constructive. So actual if you are already in the property or you're holding the property, or constructive meaning you are not in the property but they're holding the title, so that's constructive. Or your name is the one registered in the registry of deeds, Registration, meaning any entry made in the books of the registry, including both registration in its ordinary and strict sense, and cancellation, then annotation, and even marginal notes. So annotations, these are the adverse claim and les pendens. It is the entry made in the registry which records solemnly and permanently the right of ownership and other real rights. So our registration system in the for for immovable properties is under the torrent system. Okay. If it's not registered under the torrent system, Article 1544 still applies. You just present the oldest title or oldest document. Yeah. Now let's discuss jurisprudence or cases which have been decided by the Supreme Court. According to the Supreme Court, if second sale is a judicial sale, meaning it is by way of levy on execution, so there is participation of a court because it's a judicial sale. Levy means foreclosure, no, or forfeiture on execution. This happens when a creditor files a claim over a person who is indebted to him. Then he won the case. Then he presented a property to the court that is owned by the debtor. Mr. Court, this is a property owned by the debtor. I will apply for forfeiture or levy. So once it is levied, it is seized by the court. It's now the sheriff who will seize. That's why sheriff are roaming around to look for the property. So when the sheriff seizes the property, then there would be execution, no? And that would be by bidding or by a way of sale. Now the buyer, in this case, merely steps into the shoes of the judgment debtor. So if it is already sold, then whoever buys the property is now in possession of the property. He merely steps into the shoes of the debtor, the judgment debtor, meaning that that person is already judged as a debtor. After presentation of evidence by the creditor that this person owes me, then okay, he's a debtor without question. No? Outside of such situation, must apply to conflicting sales over the same unregistered parcel of land. So this is the rule. If sale 1 occurs when land is not yet registered, and sale 2 is done when land is already registered, we apply the first in time priority in right. So because this is already outside of Article 1544. Yeah? So again, if sale 1, the first sale was occurred when the land was not yet registered, then the seller probably registered it without the knowledge of the first buyer. Then a second sale was made to another person by the seller. Then we apply whoever is the first in time as the priority in right. So of course there are valid sales, no? Sales is 2, sale 1 and sale 2. So seller should have executed a deed of sale. So whoever has the first date, if the date here says that it was made in May 1, 1980, and sale 2 was made in May 1, 2010, So, of course, whoever has the last or oldest title, then whoever is first in time is given the priority and right. Another case in Gabriel versus Mabanta, the Supreme Court says that good faith must concur with registration. To be entitled to priority, the second purchaser must not establish prior recording of his deed, but must have acted in good faith. So, if the registration, meaning if the registration was done without, in bad faith, still that registration holds no water. No, according to the Supreme Court, in registering a property, it must be done with good faith. Now we discuss condition. In some cases, a sales contract or a contract of sale is subject to a condition. So what is the effect if the condition is not fulfilled? Okay, it could be the buyer or the seller. So the other party may refuse to proceed with the contract, or proceed with the contract, then waiving the performance of the condition. So meaning the condition is no longer uh, no longer part of the contract. Letter B. Now, if the condition is in nature of a promise that it should happen, then the non-performance of such condition may be treated by the other party as a breach of warranty. Okay. So that is effect of non-fulfillment of the condition. No. So again, the other party may refuse to proceed the contract or proceed with the contract, or thus waiving the performance of the condition. So if condition is a nature of promise, except if it's a promise, then it should happen. So non-performance may be a breach of warranty. Another condition, if the buyer has already sold the goods. So, we have a problem here. The buyer has already sold the goods. Then the general rule, the unpaid seller's right to lien or stoppage in transitu remains even if the buyer has sold the goods to another person. So the stoppage in transitu, meaning in transit, the goods are still in transit to another person, then the seller can stop it. So here it is the buyer who failed to pay. It's the unpaid seller. The condition is payment, and the buyer failed to pay. But he sold the goods. What kind of person is that? No. So according to the general rule, the seller is unpaid, is right to lien. What is right to lien? He has a charge over the property. Well, he can claim a charge to the property, or he can stop the property while in transit. If it remains, transito remains. Okay. So those are the seller's right. Right to lien or right to stoppage in transitu. So there are two rights. No? So except when the seller has given consent thereto, meaning the seller has already uh, approved or given consent to the buyer, okay, you can sell the thing to another person. Oh, that would be an exception. Or when the buyer is a purchaser in good faith for value of a negotiable document of title. So this pertains to the to the buyer of the buyer. The buyer is a purchaser in good faith for value of a negotiable document of title. So there was already a document of title which the seller has transferred to the buyer. Okay, like what are the documents of title again? The warehouse receipts, bill of lading, like that. The bill of lading was already given to the buyer, so the buyer has now a valid negotiable document, so he can transfer it to another person. So if that person is holding the bill of lading, then this is a purchaser in good faith of the document of title. So these are the exceptions. No? So here are the negotiable documents of title. They are found in Article 1636. Okay. So documents of title are not creation of law, but by merchants to allow them to deal with merchandise without having to physically carry them around. Like what I said, warehouse receipts. Now, if the owner has a un, what do you mean? What do you call it? The grain of rice which are not yet processed, no? Pumagaling, unmilled rice. So after milling, the miller has a warehouse. So he just stored it in the warehouse of the miller. The miller is the one who grinds the rice and takes away the peel of the rice. No, takes away the peel of the rice. So the rice now are put in the sack and placed in the warehouse of the miller. So the miller now has. So in order to claim that those sacks of rice, let's say the planter uh, the planter gave the miller 1,000 sacks of unmilled rice, then after milling it becomes 500 sacks of rice, no? Because one half of it will are the peel. So 500 sacks of rice are now in the miller's warehouse. So in order to prove ownership, the miller will write a warehouse receipt stating that Mr. Planter here has a stock of 500 sacks of rice in my warehouse. Okay, this is a warehouse receipt. It's given to the farmer or the planter. So the planter or the farmer now can deal his sacks of rice in to any buyer without carrying his 500 sacks of rice with him. So he just transact business by showing the warehouse receipt. So without physically carrying the 500 sacks of rice. So the document of title pertains to specific type of movables only. For goods, the documents of title serve to two functions. What are these functions? Okay, first, as evidence of existence and possession of the goods, which are described in the warehouse receipt or in the document. Then as medium by which the seller is able to transfer possession of the goods to any buyer or to any person. No? So a document of title which states that the goods that referred to therein will be delivered to the bearer or to the order of any person named in such document. So therefore, that document is negotiable by delivery, no? Or endorsement. So it's like a negotiable instrument that the holder, the one who is holding, can negotiate it by mere delivery. No? If it's in blank, no, There's no name stated, so whoever, oh, there's no name in this warehouse receipt, so okay, we can write my name. So that is by negotiable by delivery. But if there's a specific name or a special name which is stated in the warehouse receipt, like this is very delivered to Juan de la Cruz. So Juan de la Cruz is now the holder. So he will now endorse it to Maria Clara. Okay, so just write the document negotiated by endorsement to Maria Clara, signed Juan de la Cruz. So that is, the document now is transferred to Maria Clara by way of endorsement plus delivery. So let's go to the types of endorsement. So I already discussed. If it is in blank or deliverable to the bearer, if it says deliver to the bearer, so whoever bears the negotiable instrument, meaning whoever is in possession, the bearer, so this can be negotiated by mere delivery. Or if it is deliverable to a specific person, there's a special name written in the document of title, then his order his order, then negotiation must be made by endorsement plus delivery. So already explained. Even if the face of the instrument says non-negotiable, we are talking about document negotiable document of title, it is still negotiable. The limiting words does not destroy its negotiability. So even if it says non-negotiable, still negotiable. If order instrument and no endorsement was made, that is equivalent now to assignment or transfer. No? So there is another kind of document title which is non-negotiable. Okay. Now let's discuss the effects of unauthorized negotiation. The validity of negotiation of a negotiable document is not impaired by the fact that the negotiation was done in breach of duty, or that the owner of the document was deprived of the same by loss, theft, accident, fraud, mistake, if the person to whom the document is delivered is in good faith and without notice of such said irregularities. So meaning uh, if the person who is negotiating the document is just found that document, and the person who receives it or who bought it is a person in good faith, is it still valid? Let's say a negotiable instrument is lost. Somebody found it, then negotiated it, and this person is now is a person in good faith. Now, is the negotiation valid? According to the rule, it's not impaired. No, it's still valid. No. So what the owner of the negotiable document of title could do when he found out that it was lost is to notify the warehouse man. Hey, Mr. Warehouse man, do not deal with this document because it's already lost. No, because if you are the buyer and you are in good faith, you must call the warehouse man first. It's still, and you will ask him if the document of title is still good. No, all right. So these are the important considerations as far as negotiable document of title are concerned. Number one, negotiation gives better right than assignment. Assignment is just transfer. Because assignee Takes document with defects of the assigner. And as an assignee also cannot anymore transfer or cannot negotiate, no? Because he is just a mere assignee. He has no authority to negotiate it to another person. Obligations of bailee, meaning the warehouse man. The bailee is immediately bound to the document. Meaning if the bailee is presented with the document, he must make good of his promise to deliver the goods to that person, to the bearer, or to the holder of the warehouse receipt. So what are the warranties on negotiation? So these are the warranties, no? When a person negotiates the document, that the document is genuine and that he has legal right to negotiate or transfer it, that the person has no knowledge of fact which would impair the validity or worth of the document, and that he has right to transfer title of goods, and the goods are merchantable or they are fit. Maybe fit for use or fit for the purpose or fit for consumption. So these are the warranties of a person who negotiates a negotiable document of title. So what if the goods which is covered by negotiable documents of title or non-negotiable documents of title is subjected to levy or garnishment? So again, levy or garnishment is seizure or foreclosure by the court, no? And the sheriff is the one handling the seizure. The sheriff is an officer of the court, just implementing or executing the order of the court. Again, documents of title can be either negotiable or non-negotiable. So if it covers a non-negotiable document, then the notice of garnishment is already an operative act to transfer title or possession of the goods in favor of the assignee. So the assignee is the judgment creditor. Or before notification, it can still be subjected to garnishment. Wala pa yung notice, pwede ka pong mag-garnish. Then if the document and the goods is covered by a negotiable document of title, then the goods cannot be levied or garnished when the documents are already with purchaser in good faith. Okay? So if it is already in the hands of a purchaser in good faith, then it can no longer be levied or garnished unless the document is surrendered or the document is pounded by the court or the negotiation has been stopped, no? Meaning it's enjoined, meaning it has been stopped. So here, if it is a non-negotiable document of title, then pwede, no? Even if there was still notification, then even before notification, it can still be garnished. But if it is covered by a negotiable document of title, it cannot be levied anymore or garnished, meaning the goods cannot be garnished or levied anymore or seized by the court if the goods are already in the hands of a purchaser in good faith, unless this exception will apply. Document has been surrendered, document is pounded by the court, and the negotiation has been stopped. Okay. Now let's discuss the difference between negotiation from assignment. This is as far as the transfer. What is the effect of transfer? No? So effect of transfer, the transferor or holder acquires title over the goods. if it is negotiated to him. If the document of title has been negotiated to him. So how do you negotiate again documents of title? By endorsement plus delivery or by delivery, if it is a bearer instrument. No? While in assignment is just transferring. So the transferee acquires title to goods against the transferor. So meaning he just acquires the goods as good as that of the whoever transferred it to him. So whatever is the title of the transferor, he acquires it. No? Now, if the transferor is a person in bad faith, meaning he's a theft example, then the assignee also acquires the title of the theft. No? And then ang document of title was stolen. So the transferor is a theft. Therefore, the assignee is also a theft. So that is what is meant here. And the second one, as far as the bailee is concerned, meaning the warehouseman, in negotiation, the bailee has direct obligation to the holder, as if it was directly dealt with him. Yes, it was directly dealt with him. So meaning the bailee, the warehouseman, cannot deny the right of the holder, as if the holder was the one who transacted it first to him. Or the bailor, he's the bailor, no? Because the parties in a warehouse receipt is the bailee and the bailor. So if it is negotiated by the bailor to another person, then this another person who now collects the goods from the bailee cannot deny him, because as if this person is the bailor. But in assignment, acquires right only to notify the bailee, the warehouseman, so that he acquires obligation of bailee to hold the goods for him. Okay, so that's the only right that the assignee or the transferee acquires. No, he can notify the bailee, please hold the goods for me. Okay, those are the topic of part 3. So next time in part 4, we'll discuss the sale by non-owner or by one having voidable title. So we already discussed the documents of title and obligations of the buyer. So we will continue next time. So if you have any questions, clarifications, or any suggestions, you write or call me. You know my Gmail account, Maceren Law, and you know my number. Or you can text me or chat me in my MS Teams account. Thank you everyone, and have a good day. Keep on learning, because knowledge is power.